Afternoon. We are here live with Judge Carolyn Thompson and lawyer Tiffany Lesnik, and they will be answering some questions that they will have today in their question and answer for you. If you have any comments and we have time at the end, they will answer them for you, so please drop them in the comments below. Also, they will give a disclosure that this is only advice for those practicing in North Carolina, but I will let them say that, and I will step away.
Hi, ladies. It's good to see you. I'm Tiffany Lesnik. I am an attorney practicing family law in Raleigh, North Carolina. I am licensed in the state of North Carolina. And as Lauren said, the advice that we're giving today is exclusive to the state of North Carolina. Family law differs in all states. So depending on where you live, your laws may be very different there. So the advice we're giving today may not be applicable in your state. And I'm going to let Judge Thompson introduce herself.
Hello, everyone. I'm Carolyn Thompson, former district court, former Superior Court judge, and current candidate for the Court of Appeals. I'm here also to help you understand what it looks like in the family law court when we're dealing with some of these questions that are coming in. But please be sure to ask us questions online. If we have time at the end, we'll be happy to answer them for you. So we've got some questions that have already come in.
We do. We have some questions that have already come in. And Judge Thompson, just to remind everybody, we have 2 sessions at the retreat this year. The first one is on Saturday at 11 a.m. And that is on how to put your best case forward. So whether you're representing yourself, whether you're working with an attorney, if you're dealing with a situation with domestic violence, an extremely conflictual ex, we're going to give you some tips on how to have the best possible case. Yes. We'll also be talking about alienation, which I know is a concern for a lot of women here at the retreat. And so join us at 11. We are also offering a Q&A session at 2 o'clock on Saturday. And so you can submit. I think we're having a technical. Oh, okay. Our screen went dark here. We're in the law. We're not like technical gurus, but we're offering a Q&A. You can submit your questions in advance. It'll be a group session, and your questions can be submitted to Tiffany, which is Tiffany at Lesnik, LESNIK law.com, and we will try to address as many of those questions as we can in that group session. And so we do have a few questions that have already been submitted, and we're going to discuss a few of those now. We'll probably address them at the Q&A as well, just in case the folks who submitted them are not watching live today. But so the first question, you want to go over the first one, and we're not going to say the names to protect confidentiality.
Well, this person sent in a couple of questions. What circumstances do you recommend filing separately when you take, this is a tax question. I have a couple of questions regarding filing taxes or retirement money while going through a divorce. I'll list my circumstances, but I'd like to give varied answers so others may glean from your knowledge, so please do. What circumstances do you recommend filing separately? Well, under the circumstances, as soon as you're able to determine the date of separation, please be mindful that whatever's in the accounts, whatever tax circumstances exist, the date of separation is key. I would recommend as soon as possible to begin separating the accounts, because one, that shuts down the exposure to violence and having to communicate with the offender or the abuser.
Absolutely. Yeah, absolutely. Excellent point. The other thing, anytime we're talking about taxes, is that we both have law degrees. We're not CPAs. We're not accountants. So anytime you have a very specific tax question, always seek the advice of a certified public accountant with regard to taxes. But if there's concern for tax evasion, or you're concerned about liability from the IRS or the Department of Revenue, I always advise my clients to file separately. Because if your name is on that tax return and there's liability that you owe taxes, or there's audits performed and years and years down the road, it's determined that you owe money to the IRS, Department of Revenue, will come after both of you.
Absolutely.
So if there's any concern about your ex or your current husband, fraudulently filing their taxes. I always say keep it separate. Don't do joint.
And sometimes clients have said that they can't get access to the tax return because he or she controlled everything. So you could actually download a transcript from the IRS.org website if you have the Social Security numbers for both of the parties.
Yes, absolutely. You just go online and do IRS transcript to do that. And then I think there was a secondary question. What happens if your husband cleans out his retirement accounts? Her husband did this after he moved out of the home and before they filed for divorce.
All of that can come out in discovery anyway. If you have an attorney, when you're getting ready to go through the divorce proceedings, there's a procedure where lawyers will actually get into discovery about what was in the accounts on the date of separation. So it's not like it's just totally gone. There will be an accountability period.
And yeah, and absolutely anything that existed at the date of separation. So whether it's a retirement account, a bank account, anything that had assets in it, we take the value on the date of separation. So just to make things easy, let's say you had $100,000 in a retirement account. We're having technical difficulties again.
Oh, no.
Sorry, give us a second.
We are all good. We are still live.
Okay.
Good.
So I'm not touching that again.
Yes. Just let me know. I'll come touch it.
So if you had $100,000 in the retirement account, and your husband withdrew that money, you are still entitled to half of that, generally speaking. So $50,000 is going to come from somewhere. The problem that we have is we want to be proactive rather than reactive. So it's better to get a lawyer and have someone help you, whether that's filing for a temporary restraining order to prevent him from withdrawing that money, because it's better to preserve what's there while it's there than to have to try to come up with $50,000 that doesn't exist anymore. So you're still entitled to it, but if it's not there anymore, you may be in for years and years and years of legal battles trying to get him to pay that money back.
Yeah, and how I try to explain it as well is anything that's acquired from the date you say I do to the day you say I don't anymore, that's the marital estate. It belongs to the marriage, not to you and not to him. So please be mindful that just because he took it away and it had his name on it. Same thing for cars. I hear a lot, well, that's his car and that's my car. If it was acquired during the course of the marriage, it's marital property.
Yeah, absolutely. And it doesn't matter whose name it's in. You know, if he put everything in his name, he kept you out of all the finances, you had no control over anything. He said, it's mine, it's his income, it's his accounts. That is absolutely not true in this state. And again, it's North Carolina. We are not a community property state. So other states are going to be very different with regard to how they treat distribution of property. But even if it's in his name exclusively, you are still entitled to a portion of what existed at the date of separation. And then let's moving on. So we have another question. Judge Thompson, do you want to read that one?
So my question is, under what circumstances can a person experiencing DV, no police reports, no physical abuse, leave to stay with family across state lines with children? Wow. So whenever I've had an ex parte, and it's just simply, ex parte means you are doing it outside the presence of the other party. There are some circumstances that really are that deem emergency, kidnapping, abuse, those kind of things. As a judge, we listen out for, but be mindful that if your whole focus is just custody and getting primary and exclusive custody, more than likely the judges will see through that and not grant the emergency relief that you need to go across county lines or state lines for safety purposes. So it's very important that you outline not just one instance, but a couple of instances and circumstances that would outline for a judge, these are the reasons I'm needing to relocate, and be mindful that you may have to come back to the state to have a follow-up hearing.
And Judge Thompson, when you say outline, do you mean specifically acts of domestic violence?
Absolutely. The more is better, because if you just say, I'm afraid because he yelled, and leave it like that, it has to just talk to us like it happened and we were not there, because judges are just are going to look at what's in the black and white on the paperwork.
Excellent point. And I tell this to my clients all the time is you have to be able to retell your story to the judge as if you're living through it again. And that is really hard for women because they don't want to re-experience the trauma.
It's black again.
But just saying he yelled or he was mean isn't sufficient. Talk about how to yell, how loud was his voice, was his face red, were the veins popping out of his neck, was he slamming his fist down, was he in your face? I mean, describe with a lot of adjectives.
And for the kids, their reaction, describe how the children reacted in the presence or earshot of what you were experiencing.
Absolutely. And I tell my clients to sit down and create an outline. So chronologically, go from the most recent and then go backwards. And you will be amazed at how much abuse you've repressed. It's a safety mechanism. It keeps you in your environment and being able to tolerate what you're living through. But once you actually start writing things down, you'll be amazed at what you begin to remember. And having it written down also helps you when you come before the court, because when you come before the court, you're going to be nervous. And you're going to forget everything. And so if it's written down, that helps you keep all of your thoughts and emotions organized so you can present those in a mindful way. One of the things coming to this question about kidnapping, so I have kind of like a top 5 list that I've created with abusers. And one of the things that they love to do is throw around the word kidnapping. Do you want to, I don't mean to put you in the hot seat, but do you want to talk about what would constitute kidnapping in North Carolina?
So I had a situation where the dad in the middle of the night took the child and the car from New York, brought the child to North Carolina. And when the wife returned home in the middle of the morning from working overnight 3rd shift, the house was cleaned out, and he already had an emergency order waiting for her in North Carolina. And she actually needed to file the kidnapping charges because it was without her consent or knowledge or a reasonable explanation for going from New York and to North Carolina. So when it came to Carolina, that hearing lasted at least 3 months, but criminal charges were also necessary to deal with moving the child across the state lines without prior consent.
So Judge Thompson, are you saying that she had a court order in place giving her custody and dad took the child?
Dad took the child.
And so that's a distinction. So if there is a court order in place giving custody to one parent and then the other parent takes the child across state lines, depriving that parent of their court-ordered custodial time, that would be kidnapping. But if there's no court order in place and you are just 2 biological parents, you both have 100% rights to your children. You cannot kidnap your own child.
That's right.
They belong to you. The biggest risk that you have is removing your children from state lines and risking your ex filing a motion for emergency custody and then having your children brought back to the state. So back to the documenting, you document domestic violence, call the police when necessary, file a domestic violence protective order, restraining order. You've got to show, I think, the court, as Judge Thompson was talking about earlier, that there is domestic violence and that's the reason you had to flee. And anytime you have a domestic violence protective order, I know the judges in White County look at that when they're evaluating whether or not to grant an emergency motion for custody. But if you don't do anything, you don't have any proof, you don't have any evidence, no audios, no reports to the police, no witnesses, nothing, it can be really hard to overcome a motion for emergency custody, and you're likely to have to come back to this state.
And when people are in the middle of separating, whether you're married or not, be mindful that if the child goes for a visitation and doesn't come back without a court order, no law enforcement officer is going to knock on the door and say, hey, you got to get the kid back. Because as she mentioned, as Attorney Tiffany mentioned, is that you have 100% equal rights to that child. So if you have like a little something going on in your spirit and you're saying, I really don't think this is a good time to visit, or he may not send back the child follow that instinct and go ahead and get something in place, be it a co-parenting agreement or something in writing to say that this is the schedule so everyone knows, bring back time. But without a court order, just be mindful that it's likely that you're going to end up in court asking for emergency relief because law enforcement is not going to be able to help you get your child back.
That's true. The court can issue an order for arrest, or the court can issue an order requiring law enforcement to remove a child.
But if they don't have a custody order
Right.
in place, it's fair game.
Yeah, absolutely.
Yeah.
The one thing that I will say, I do a lot of work with domestic violence, is stall. You know, it's a practical tip. It's not a legal tip, but just stall.
Mm-hmm.
So let your spouse know, hey, I have the children. We're safe. I'm not intending to leave North Carolina permanently. I just need a break.
Mm-hmm.
You know, I need a short break. I'm going to stay with my family or friends for a few weeks. I'm upset about the way you're treating me, but I'm coming back. You know, put things in writing so that they know you're not going to be gone permanently. Narcissists are great manipulators, but they can also be manipulated greatly. So, you know, they're begging for reconciliation or they're begging for you to come back. Use that to your advantage to stay away as long as you can.
Mm-hmm.
And hopefully you can get to a point where maybe you're long enough that you actually establish jurisdiction in the state that you're in. 6 months is the general kind of rule.
Mm-hmm.
And you could potentially file for custody in the new state that you're in. And this leads to another point. It wasn't a question, but usually where you file first is going to take control of your case.
Yes.
So if you let's say you flee to Montana and you file in Montana first, if he files a counter lawsuit in North Carolina, usually Montana is going to be able to take that case.
Right. And what I have done is actually call the judge presiding in the other state, gotten off the bench, go into chambers and call and ask if that judge wants to keep jurisdiction or if they're okay with transferring it to North Carolina. But if that judge in the other state says, no, it's filed here first, it stays there.
All right. So we talked a lot about that.
Mm-hmm.
But that is, kidnapping is one of those big things. So that's one of their threats that they use.
Mm-hmm.
Seek legal advice, talk to an attorney before you do anything, because that can have major implications for you and your children. And so the next one, do you want to read this question or give a synopsis of what this question is about?
Wow, this is a lot. I'm divorced with 2 children and my ex-husband and I currently have joint custody over them both. Not really sure if she means that they already have legal custody or if this is just an arrangement. We have a kindergarten son who's been struggling this year, and his teacher and principal both recommend that he repeat kindergarten. I think it's a great idea, but my ex-husband is adamantly refusing. We've had 3 meetings to discuss the possibility of holding him back. My ex-husband is not budging on his opinion. Do you have any tips to avoid mediation or court for something like this? I contacted my lawyer and I'm prepared to pay a retainer fee and go through this process if I need to, because I think it's very important. But I wonder if you have any advice for coming to a decision without taking these steps. Wow, that's a mouthful. All right.
So I think that depends on, you said you're divorced, but it's going to depend on whether there's a court order in place or not.
Who has primary decision-making power. I always make sure in the court orders that if the parties cannot agree, that the primary custodian or the secondary, depending on how they agreed, would have the final say in situations like this, medical, educational, major decisions about the child.
And if you do have a court order in place and you have joint legal decision-making authority and you make the decision contrary to, what he wants, then you run the risk of being held in contempt of court. And not only does that come with the risk of potentially going to jail, paying attorney's fees,
Fines.
Fines. I always feel like anytime you're held in contempt, it kind of puts a negative mark on your file, so that if you come back for custody later, the judge is kind of looking and saying, hey, you've been held in contempt before. You're not necessarily the best parent to have primary. But if there's no court order in place, if you all either just have a parenting agreement, a separation agreement, or there's no agreement between, actually, let me address no agreement versus having an agreement. So if you have an agreement in place that's been signed, I will usually tell my clients, you can disagree. So I will usually tell my clients, follow the professional recommendations. So if If the teachers and the principals are saying this is what needs to happen, I will usually say go ahead and follow those recommendations. He can sue you for breach of contract. If you do that, there's a potential risk that you'd have to pay his attorney's fees if he did, but I can't imagine that a court is going to say, even though the child's been retained, I mean, you can't enforce the agreement
but you've got
anymore.
the school records, you've got the recommendations in writing, and it's going to take every bit of 30 days before you can even get in front of a judge. But at the end of the day, the child is getting what he needs.
Yeah, exactly. And if you don't have an agreement in place and there's no court order in place, do what's in the best interest of your children, recognizing that he's going to fight you all the way. And so it's going to be an uphill battle. But a tip would be to avoid court, to avoid all the game playing. There are therapists that actually offer like conflict resolution sessions for issues such as this. And they can kind of help you work through and help you all come to an agreement for a minimal copay, much cheaper than lawyers. And hopefully you guys can reach an agreement. If that doesn't work, I would suggest mediation. It's still going to be a lot less expensive than filing a lawsuit.
And I know in my district, you can actually go to mediation without having to file a custody order, but you just sign up for it. You can go in and he or she's a third party, not interested in either your case, not an attorney, and you say, okay, I just want an opportunity to flesh this out. Maybe then you can come up with a parenting agreement that would be later on incorporated as a part of your existing order. But every time, custody is not permanent, even though we call it permanent custody. As long as the child's not 18, you can always address modification issues or issues such as this.
Absolutely. So just as a reminder, I think we're running out of time. Just as a reminder, we are having a Q&A session on Saturday at 2:00. So if you have, we hardly got to cover most of what was sent in, but if you do have questions, feel free to send them to us at Tiffany@lesnik-law.com. I have a table set up in the bookstore. I have business cards, and why not you can grab a business card. It's got my website and the email on there as well. I hope you will submit your questions. Look forward to seeing everyone at the retreat, being able to hopefully provide some information to you and help empower you this weekend.
Just remember safety first. If you don't remember anything that we've said today, safety first.
Absolutely.
Thank you.
This will be available post-retreat access too, right?
Okay, yes,
Yeah,
absolutely.
So they can access this afterwards. Thank you guys for joining, and yes, send in your questions. And if you're not at the retreat and you have questions, if you leave them down below, I can tag Tiffany Lesnik or submit them to her myself. So just go down below and leave your questions, and I know they're happy to answer. So thank you ladies so much for your time today. We appreciate it.